Hi, good afternoon, everyone. This is Rajiv Khanna from immigration.com, the law offices of Rajiv Khanna, PC. Um, this is a community conference call we do every other Thursday. Today is September 17th, 2015. Today is an unusual day. We kind of screwed up. We usually stop questions at 20, and that gives me enough time usually to finish questions and answer a few new questions. But today is a very unusual day. We've got 40 questions already. And if you think about it, that leaves me, if I were to do this in 1 hour, which is the aim, I would only have about 1 minute and 30 seconds per question. That doesn't give me a whole lot of time. So number one, we will not be able to do any new questions today. And number two, there is a high likelihood I am not going to be able to do any give and take. I'll go through the questions. I will answer them all for you. But if this trend continues that we have many more questions than answers, I will definitely, beginning January 1st, I'll start doing calls. That would be the plan on a weekly basis instead of every 2 weeks. So for today, I just want to caution you. I'm going to have enough time just to answer the posted questions, and even that is going to be stretching it. We will not do any give and take, and we will not take any new questions. Okay, so let's begin. Anil Nair says, question about H1B extension after I-140 approval. I-140 has been approved August, working with another employer since last year. New employer is filing PERM, I-140, but they are using old employer's I-140 approval for H1B extension and priority date. But the old employer is not providing I-140 approval notice copy. They've given PERM and I-140 approval receipt notice number. Can I file H1B extension with I-140 approval notice number? Yes, you can. We have done this already, guys. Since the last time I announced this, a few more people have logged in. Regretfully, I will not be able to do any new questions today. We have our plate more than full, and we might not even be able to do any give and take on the questions that are posted. By my count, I only have about a minute and a half to answer every question. So I hate to disappoint you folks, but I am going to read through all the questions and answer them. May not be able to do any follow-up or new questions. Sorry about that. Okay, so, but I just did say that beginning January 1st, if this trend continues, we will start doing these calls on a weekly basis instead of every 2 weeks. Okay, so I have a question about H1. Again, going back to, is it possible to file H1B extension with just a receipt? And the answer is yes. We have done it. We do it many times. We don't have the approval notice. In those cases, we go ahead and file with whatever information we have, including a number. Okay, so go ahead and file. Next question is Neil. I am on second H1B extension, good till 2018. First one was approved for 2 years. Started my green card process, filed PERM. Once PERM is approved, can I file I-140 and 485 concurrently? Well, if your wife's country of birth, Panama, is current, which it is for EB2, then you can file I-140 and 485 concurrently. Even though she's on DACA and she has 10-year bar, I am not aware of any law that stops people from using cross chargeability because there is a disqualification on the spouse. Have this double checked, but I think you can, Neil. Okay. For people who have just logged in, I may not be able to do any new. Actually, I'm quite sure I'm not going to be able to do any new questions. We have enough posted already, and in fact, we may not be able to even do any follow-up. Okay, but I'll try. So Ritesh Satani says priority date retention. So I-140 was approved through one company, EB2 was filed along with I-140 and 45 concurrently with the second company in October 2014. EB2 I-140 got approved with priority date retained as of March 2008. My I-485 is now pending for 11 months. So here is the interesting issue here, Ritesh ji. The problem is, current thinking of the government is that if the old employer revokes I-140, it takes away the priority date even if there is no fraud or willful misrepresentation. So the priority date is removed if the old case is um, revoked, okay, by the employer. Now, on the other hand, AC21 should protect you as far as portability of the green card is concerned. But does AC21 also protect your earlier priority date? I would say yes, that's what I would argue. So chances of you keeping your priority date are pretty good. That's what I would suggest. If your as yours is 485 has been pending more than 180 days. So your questions are, will I lose my priority date? And the answer is, I hope not, but I can't say definitively. I think AC21 will protect you. Um, yeah, I have actually answered all the questions. All three questions are the same content basically. There is a frequently asked questions that I have marked as such as it's a I-485 adjustment of that status, AC21 issues in job through future employer. I want to make this clear. This comes up quite frequently. So again, with the constraint of time that I have, I'm going to do a quick outline for you. Unfortunately, the intention of this particular conference can only be to make you aware of the issues so you can follow up. I hope that I can guide you enough so you're sensitive to the issues. It is perfectly legal for an employer to process the green card for you as long as they have the good faith intention and you have the good faith intention of joining them. However, once I-140 is approved and 485 through a future employer has been pending 180 days, you are not required to join them. You could join anyone with same or similar job anywhere in the United States. So AC21 protects not only jobs that you have in hand, it also protects future jobs. The question is mostly of good faith intention, and that's something inside your head. That's not somebody, they cannot investigate what is inside your head. As long as the intention is honest, and basically that is based upon your statements, that's all that matters. Once again, I'm cautioning people who are just logging in, guys, no new questions, probably no follow-ups even on the posted questions, but I will answer the posted questions. Okay, so the questions that this community member had posted were this. I am working with employer A on L visa. B filed future employment under EB2. I-140 is approved. Never worked for them. 485 filed by employer B pending more than 180 days. So now you are protected by AC21 job portability or green card portability. You can take any job anywhere with any employer as long as it is similar to the job described by your employer B when they filed your green card. I think there's a question somewhere along the line that I just have an I-140, there's no job description. Well, job description is on your PERM application, whatever the PERM application says, okay? I want to join employer B. You don't have to actually. If I cannot join them during I-485 adjudication, if I get a request for evidence, can I use another job offer from another employer? Yes, you can. Yes, you can. And you don't have to prove that this offer was extended prior to I-485 adjudication. You can, yeah, that too can be a future job offer. And the joining date really does not have to be specified. All that needs to be specified is that it is their intention to offer you the job and accommodate you either before, sometime before, or promptly after the green card is approved. Okay. Once again, new people are logging in. I remind you, no new questions today. Too busy. Thank you very much. Have a great day. Bye bye. Thank you. and no conversation on posted questions either. But I am going to answer the questions that have been posted. So you have all the options open, sir or ma'am. If you want to respond using a job offer from a future employer, employer B, employer A, all of them are open to you. And ability to pay RFE is usually only relevant to the employer who filed your green card. So if I use AC21 and go from employer X to employer Y, USCIS is not going to question employer Y's ability to pay. But if you stay with employer X, they can question the ability to pay all the way till you actually get the green card. Once again, a reminder, folks, today there are going to be no new questions, no follow-ups on existing questions. I'm just going to run through the questions, okay? Again, same individual L1B visa based upon blanket petition work location change. Okay. L1Bs come in two flavors. One, where you are working at the employer's premises, and two, where you're working at a client premises. If you are working at a client premises, I think an amendment is called for. If you are working on the employer's premises under employer's control, there should not be any need for an L1B amendment. Double check with your lawyers, but that's the way we do it. Okay. Moni Rakesh says H1B is in the 5th year. I-140 is approved EB2. If I change a company, can the priority date be ported? So yeah, priority dates can be ported across different job categories. So if you are an engineer and then become a manager, priority date can be ported as long as the old I-140 is not revoked by the employer or by USCIS. Okay. So if you become a manager, no problem. You will start a new perm, of course, but you will keep the same priority date if it is unrevoked, if the I-140 is unrevoked. What happens to H4 EAD if the H1B changes company? That should not be a problem. Only time H4 EAD could be in trouble is if H1 loses status. And USCIS has said if the I-140 is revoked of the primary H1 applicant, then we reserve the right to revoke the H4 EAD. Whether they're going to be able to do it, we don't know. We'll see. Okay. If the H1B changes company, can the H4 EAD be extended? I believe so, as long as an I-140 is approved. If there is no I-140 in play, then an EAD cannot be extended. Okay. So Arjun G says, I'm a permanent resident, wants to get married in India. Is there a spouse visa for permanent residents, green card holders? No, there is not. Guys, people who are just logging in, I'm noticing people are logging in now. There'll be no new questions, and there'll be probably no discussion on existing questions either. No new questions today, no discussion on existing questions. We have a lot on the plate. Trying to go through all of them and at least be able to guide most of you. So there is no spouse visa for permanent residents. There used to be one called V as in Victor, V visa, but that was around only for a couple of years. Then it sunset, it was never renewed. There is no spouse visa like K3 visa for citizens. There's no such thing for green card holders. You have to go through the F2A based green card process, family based process. If, on the other hand, she qualifies independently for an H1 or L1 type visa where filing of the green card is not an issue, then she can come on that even while you file for her green card. Do not take the route of inviting her here on a tourist visa. That can be considered to be fraud. Be very, very careful with that option. I cannot think of a faster option, Arjun. I think the only other fast options, like I said, are H and L visas. Okay. There's a frequently asked question on re-entry permit, and this is from S. Manimaran, sorry. I'm a green card holder, got it in October 2011, moved to India 2013. I applied for a re-entry permit and got it, good till 2016. I want to point something out to you. There's a lot of misconception about re-entry permit. Re-entry permit does not give you an irrevocable right to stay away from the USA, but it is as close as you are going to get to security in maintaining your green card. Re-entry permit simply says this: the fact that you are away for 2 years cannot be used by itself as a ground for revoking your green card. If, on the other hand, it appears that you have no intention of coming back and you have abandoned your intention to live in the United States, we will take away your green card, even if you have a re-entry permit. As a practical matter, USCIS does not look behind the re-entry permit. So far, I have not seen any cases. Okay, but don't think it's a foregone conclusion just because you have a re-entry permit, you're 100% protected. No such thing. So another thing to remember is you don't have to visit USA even once while the re-entry permit is in play. But you must enter USA before the expiration of re-entry permit if you want to extend it. And extensions can only be done while you are physically present in the USA. You cannot send application via courier from India like you have asked. So that's the way it works, okay? Next question is Mona Lisa. I am on H4 expiring 30th September. H1B extension filed for my husband in May 2015. At the same time, H4 EAD was also filed. H4 EAD approved September 3rd. So basically, she got an EAD only for 20 days. And does she have to pay the fees again? Ma'am, I have no idea. I'm pretty sure you will have to. If USCIS has made an error on the dates, and which doesn't, I'm not sure how that would play out, you can certainly ask them, but don't be too confident that you don't have to pay the fees again. Okay, so that's the way this works. Once again, people who have just logged in, I see a bunch of more people logged in. I'm not going to do any new questions today, sorry. And I may not be able to do any follow-ups on the posted questions, but I'm going to give it my best shot. I'm rushing through the questions and just so that I can have some time to talk to people who have already posted questions, but no new questions. Today I was budgeting only 1 hour, but it looks like I might go a little bit over. I'll do my best. This has been asked quite a lot. What is this new EAD rule? So you guys need to understand this. I'm going to make a more detailed video on this if time permits over the weekend. We do have a call scheduled tomorrow with our existing clients only, not for general community. I am going to, because that's more manageable, I'm going to be able to answer all the questions. Unfortunately, I can't make it available publicly because they contain people's identifying information. So, but I'll do a separate presentation, hopefully over the weekend if I get the time, or over the next week. What exactly does this mean? Let me run this through to you. What has happened is this. What is Visa Bulletin? Visa Bulletin is simply an estimation by the US State Department about what numbers or what date will be available from the first of the following month. So now we are in September. On September between 10th and 15th, the Visa Bulletin comes out. It contains family-based dates, employment-based dates, and it tells you if your date is XYZ, beginning October 1st, the first of the following month, if USCIS receives your application for adjustment of status, or if you are in the consular processing, you are getting close to getting your green card. That's the idea, okay? What USCIS has done is they intended to change and make it possible for people to file their 485 even if the priority date was not current. So it looks like they have backed off from that much more beneficial position for us into this kind of a compromise position. It's better than nothing, but not as good as a regulation that allows us to file 485 no matter what the priority date is. What they're doing now is they are saying this. Okay, So State Department issues the visa bulletin, but we USCIS will do our own count because many times adjustment of status cases are abandoned, denied, withdrawn, revoked. There are so many ways 485s can go down. To accommodate those numbers, we'll make our own guess. And if you are in the United States, if you have to listen to our guess, not to visa bulletin. However, even though you filed 485, it does not mean that you are going to get your green card at the same time. Green card will still depend upon visa numbers, which are the domain of the State Department. So State Department's guess is what will get you your green card. USCIS's guess is what will allow you to file 485. That's what's going on. Because once you file 485, you have the benefit of the EAD, your spouse has the benefit of the EAD, plus you get blessed by the portability clause where you can change jobs. So it's a good thing, but not as good as we would have liked to see. So who knows, they might come back and still make it as good as we want it to be, which is file 485 with the I-140, or even if the I-140 is approved, no matter what the priority date is. Okay. Next question is Ajay Datta. My priority date is December 2010. There's an I-140 approved from previous employer. Recently switched jobs. They have initiated PALM. Can I file AOS, EAD, AP based on my previous employer's I-140, but use the letter from my current employer? No, you cannot. If I'm able to get my previous employer to give a letter, can I file AOS? Yes, as long as there is a good faith intention to give the job and take the job, you can take the prior employer's letter and file the case. After 180 days, you can join any employer, continue with the same employer, as long as it's the same or similar job. Next question. Surendra S says, I'm on H1B, I-140 is approved, priority date is 2013, I-140 approved from our head office. So this is a little bit more complicated, not sure how much I can cover, but I can give you some hints and suggestions. So you got your case approved through head office. The PERM was approved, I-140 is approved. Then you took an internal transfer to North Carolina. And your legal team is saying either start the new green card process all over again, or once the final stage of the green card has been approved, you'll be required to immediately return to work in the old office. And the answer is, why can't you use AC-21? A file with the good faith intention to return, but if you choose not to return after 180 days, would not AC-21 protect you? So please ask them. I think it will. So I can't go into any more details than this, but just tell them that there's a lawyer in Washington, D.C. who said, why can't I file with a good faith intention to return to the headquarters? Then after 180 days, if I change my mind, that should be okay because AC-21 protects me. I think so. Okay, next question is Katraj. Priority date port and multiple I-485 AOS petitions. This is also another set of frequently asked questions. And guys, some people have logged in again. No new questions, probably no follow-ups on posted questions. Today we are a little swamped, okay? Bunch of things I want to talk about here. First of all, as I've said before, current thinking of USCIS is if the old employer revokes I-140 or USCIS revokes I-140, we'll take away your priority date. Okay. Second thing is, I was asked this question yesterday by a client that, look, when I filed the second I-140, USCIS already gave me the date from the old I-140. Now, if the old I-140 is revoked, do I keep my date? And the answer is not necessarily. Just because the date has been put on your new I-140 does not mean you get to keep it. At least that's the way I see the law. Okay. Going back to Katraj's questions. Can I apply my I-485 with old EB3? And can I apply 485 from my wife's side also? So here's another question I'm getting asked quite a lot. Let's say husband and wife both have their 485s going because she had her I-140, you have yours. Priority date maybe a few months ahead of the other, one or the other. Should we be filing four I-485s? One primary, one derivative, one primary, one derivative. Well, USCIS does not like it. I have done it in the past because it's legal. It's not illegal. And I'm not really in this world to be liked by USCIS. My job is to do the best I can for our clients, not to be popular with the USCIS. That's not my job. As long as it is legal, I will do it. So is it legal to have multiple 485s? The answer is yes. Can it cause confusion and delays? Yes, but it does also protects a bunch of very important rights. However, here's the interesting thing, and this started happening from a couple of years. I've seen this, and but the problem is they're not always consistent. So let's say husband wife both filed 485, one each, but wife's case got approved first. What USCIS does these days is they'll take husband's case and convert it to a derivative and approve him also. So they automatically convert pending 485s from derivative to primary, primary to derivative, which is very good. Uh, so bottom line, can you do it? Can you file multiple 485s? Yes. Should you do it? Let your lawyers check with USCIS. I probably would. Where there's advantage, where there's no advantage, both jobs are secure. We have nothing to worry about. Let's say I would probably just file one each and wait. Chances are USCIS will convert primary. When they approve primary, they'll convert the derivatives case also, of the second primary's case also as a derivative and approve it. I hope I made myself clear. Okay. Next question is Rekha SP. My question is regarding the second set of dates. I already explained what these dates mean. Guys, people who have just joined in, I will not be able to do any new questions. I will also not probably be able to do any follow-ups on posted questions. You're welcome to stay, but if this is going to be basically a recording, and I think I'm covering everything. And I've indicated this before, if this trend continues of very high questions, high number of questions, beginning of next year, January, I'll start doing calls every week, okay? So there's a bunch of confusion here. Okay. Now, let me clarify. I've said this before that the way you would do it is if you are in the United States, forget about Visa Bulletin, go to the USCIS website, and the information is on my blog. You can go to my blog, and I have an entry on that. You can follow my tweets. Just go to that page, it will tell you what AOS USCIS is allowing. Okay. So even though Visa Bulletin says the priority dates are backed up, USCIS could say no, they are not, and accept 485s. You're not going to get your green card until visa numbers are made available by the State Department, which is controlled by the first table. Okay. So basically, all you need to know is look at the USCIS website. If it says priority dates are more recent than the ones mentioned in the Visa Bulletin, apply your AOS. That's the bottom line. Okay. And if you have a spouse, if you have an existing 485 and that date becomes current because of this new Visa Bulletin style, you can actually file for your spouse. There's no problem because your spouse inherits your priority date. Okay? Then we come to next question by Ash. Priority date is May 2012. Well, this is a common problem. Employer does not want to file 485. Well, 485 is really your application. All you should need is a letter from the employer. Oh, I'm sorry, this is not the same question. I take it back. There's a question further down. I read the questions. I kind of mixed them up. Ash says my priority date is May 2012. He wanted to move to a new employer. Now I'm really confused whether to take the new job or not. Ash, this is what you should do. stay at the same job, file your 485 because your dates are current. After 180 days, you can join any same or similar job without losing your green card. I think that's what makes sense. That's what I would do if I were you. Okay. Next question is a CSPA case. Monarch, I don't know the details of your case and how you're eligible for CSPA, but one thing is very important. You must be able to document that you tried to start your green card. So send an email to the consulate. Make sure that you made your best efforts to be included in the application. Send an email to the consulate. Even try to pay a fees, and if they reject the fees, keep a copy of the check. Okay? So that would be the thing to do. It's important to make every effort you can to show that you tried to get your application added on to your parents. PRS Patel has a problem with the name. Look, right now, don't worry about the cosmetic details. File the 485 with what you've got. You can deal with these issues in the RFE stage. Okay? You've got a birth certificate. Right now, just file it. Over the next few weeks, talk with your lawyers. You can't talk with your lawyers. Post your question again after we are done with this October time. Have a little bit more time on our hands. We will then talk a little bit more about it. Okay. Normally, what happens is in my office, I am free and the team is busy. But I want to keep myself free as much as possible for our existing clients. So I'm trying not to take on anything more than what our existing clients need or emergency cases that are coming in need. Okay. So I would want you to please wait until the end of next month for us to discuss any issues that are non-urgent. Okay. Next question. Sandesh says, I'm planning to apply for EB2 EAD AP 485. There's a misdemeanor conviction. You, Sandeshji, definitely need to take an opinion from a lawyer who should go over your conviction and make sure your conviction was indeed only one conviction. Maximum imposable punishment was less than 1 year. It's a misdemeanor. And sentence actually imposed was less than 6 months. That is what is a petty offense exception. Petty as in small. You can search this term, petty offense exception. But it's not something you should decide for yourself, because if you are covered by petty offense exception, then you have no problem. Okay. Next question. So we are almost half the questions, and we have about an hour, half an hour in the process. So that was kind of the pace I wanted to keep because I've got to go through 40 questions. I have a question regarding H1B, H4 EAD. Wife is on H1B visa. Guys, honest, if I had time and circumstances were a little easier time-wise, I would like to spend hours upon hours answering everybody's questions. But we are a little bit pressed for time, like I said. So thanks, Rajiv. Okay, I have a question regarding H1B, H4 EAD. Wife is on H1B visa and applied for H4 EAD last week. She's on maternity leave. Is it okay to be on H1B status till she gets her H4 EAD approval? Well, first of all, under Family Medical Leave Act, you can actually go easily up to 12 weeks for maternity leave. So while you're on maternity leave, you're still in status. There's no problem. And by the way, congratulations on the baby. So as far as I know, FMLA allows you as much as 12 weeks. You can double check that. In addition, if you have some medical requirement, you could even, it's 12 weeks in 12 months under FMLA. Next 12 months, you could probably get another 12 weeks. But if you had a medical reason, you could even be off work for a longer time and still consider to be in status, as long as the employer is keeping you on unpaid leave. Okay. Second set of questions is, first one is minor 2007. Got my I-140 approved with employer A. I'm still with him. My priority date is Jan 2012. Per my understanding, I get to retain my priority date for my lifetime, only if the I-140 is not revoked. If it is revoked, you will lose your priority date unless USCIS changes its mind. If I switch to employer B and they delay perm filing, or even if they file, will I be eligible for EAD based upon my approved I-140 with employer A? EAD does not come based upon I-140. EAD comes when you can file 485. 485 you can file if employer A is in good faith giving you a job offer. Listen to my discussion in the beginning of this session. I've talked a lot about good faith intention and how you can file. And I have discussed this issue in detail earlier. That should help you. Antariksh Singh says, H4 after F1 denial. I'm in USA, hold green card. Brother is also here, also on green card. Sister was denied visitor visa twice, and F1 also. See, Mr. Singh, if the denial was not on fraud grounds, I see no problem getting an H4. If the denial of B visa or F visa was on fraud grounds, then you won't. Then it's a permanent bar. Okay. So that's the way the law is. Raghu 2082 says currently on H1B, EAD based on EB2, perm is filed as a software engineer. I will have a 2-month internship with another firm. If I still don't get my green card, can I use my EAD to complete the 2-month internship? Yeah, as a management consultant, why not? Because you intend to join the old employer back again, why not? It's got to be good faith. And look, Raghu, you can afford a consultation one-on-one. Why don't you talk with your lawyers or talk with us? I would want you to explore this issue a little bit further, but theoretically, at least, it is not a problem. And I don't see why this should be an issue. If I had a little bit more time, I would have given you more information, but theoretically, this can be done. Just make sure you talk with your lawyers. Okay. So Janus 99 wanted to know more about the EAD rule. I discussed that at great length just a few minutes ago. And I described to people that's just a new methodology. When you file 485, just look at USCIS website, not just the visa bulletin. USCIS website will tell you whether they are going to follow the visa bulletin dates or they are going to follow a different set of dates. That's the bottom line. I'll do a more detailed presentation on this and I'll post it on our website. If you follow my Twitter or Facebook or Google Plus, you can see this information there. The thing that I do the most, also our apps. We have our new app coming out. It's actually under approval right now. So even our apps, you will find that all the updation is there. Okay. My company is not approving my EAD filing. Can I file EAD by myself? You need a letter from your company. See, EAD is not filed without 485. 485 cannot be filed without a job offer from the sponsoring employer. Okay. So you need a job offer, Rajesh. Mona, again, it looks like the same individual. Spouse is on H1B visa with company A. I am on H1B visa with company B. I-140 is approved. Can I add my spouse as she's not dependent on me? Sure. There's no law that the spouse has to be on H4. The spouse can be on H1, L1, independent visa herself. You can still file her 485. What all things I need to include to include in my green card? Nothing. Just proof of marriage and follow the instructions on the 485. Definitely not a problem. My company is not approving. Oh, same question. Can I file 485 without my company? And the answer is no. You need a job offer. Okay. People who are just joining in, we're not going to be able to do any new questions. May not be able to do any discussion on posted questions either. Pretty busy conference today. Imi Rao's has a very long fact pattern. Frankly, I kind of lost it within the first few minutes because I had such a busy calendar. But I can answer your questions generically. The questions are not difficult. but your fact pattern is actually too difficult to read. So remember, I have not read the facts. I'm just answering your questions. Per October 15 visa bulletin, um, can the priority days progress or retrogress in the upcoming months? They can. These are all estimates. So the priority dates could go sharply up, sharply down. These are all estimates. 2. Can company X file for my 485 based upon company B I-140? No. 485 can be filed only through the job offer of the sponsoring company. Whichever company sponsored your I-140, if you're trying to file 485, you've got to go with that company's job letter. Good faith job. Previous employer is willing to process 485. If I'm willing to join them, that can be done, sure. And actually, I have said this many times, you never have to join them. As long as you had the good faith intention to do so, excuse me, after 180 days, you're free to join anyone with the same or similar job. Okay. So the question is, if I have a 485 pending through one employer, and I start a green card and I-140 through another employer, can I file another 485? Actually, once the I-140 is approved, you can place it on top of the existing 485. So if you have 3 different I-140s, as long as the priority date of each one is current, you can choose to place that on top of an existing 485. You don't have to file a new 485. The fact that they are different employers doesn't matter. 5th, my wife has an H4 EAD till September 2017. Is it an option for me to just file for my EAD and file for my wife and 2-year-old dependent later? Of course. Of course. Given that they already have H4 EAD and H4 status, yes, you can. No problem. But I think you should do it together. That would be the smart thing. Guys, I see more people logging in. Only old questions. I will not be able to do any new questions. And even amongst the old questions, I may not be able to discuss anything. Okay. I'm just answering them because there's so many of them. But I intend to start, like I said earlier, next year or maybe even earlier, a weekly call if this trend continues. It's just not possible to handle all these calls in one conference call. And I like to spend my time on each question because otherwise, where is the pleasure? And you don't get helped enough. I'm not able to do a deep enough analysis. So, but here at least I'm able to guide you if nothing else. You at least get the broad strokes of what you need to do. Then number 5 question is, I already answered that, but I do recommend you file for their 485 at the same time as yours because there's many reasons for that. I would recommend that. You don't have to file EAD, you can file just the I-485. They can keep the H4 EAD. One last question. What happens to the I-140 after priority date porting? Is it option? Yeah, see, don't think of I-140 priority date as being something outside of yourself. Once the I-140 is approved, the priority date belongs to you until the I-140 is revoked. That priority date can be taken to any employer across any I-140, across any 485. Okay? It belongs to you. Next question, Praveen wants to know, my I-140 is approved from employer 1 EB2 India 2010. I've changed to employer 2. Is it advisable to file 485 under 1? Of course. Of course. I have already said this. As long as there's a good faith intention, and interestingly enough, once 180 days have gone, you don't have to join them. But at the point of filing the 485, you must have the intention to join the future employer. Okay? Is it possible to resume green card process at employer 2 without restarting from scratch? Not sure what you mean. Let's see. You can start green card with employer 2, but you have to start from the very beginning. New people who are logging in still, I will not be able to do any new questions, may not be able to do any discussion on existing questions also, just too many of them. Okay? Doing my best. Sorry about that. Okay. I know that you folks make time to log in. Case Anil 23, I have EB3 I-140 pending approval for more than 9 months. I-485 is not yet filed. I would like to change to employer B. They'll process my green card under EB2. Can I retain my priority date? Yes, as long as employer A does not revoke it. And priority dates can be transferred across categories. First one was EB3, second one was EB2. You can transfer it across categories. Folks, once again, I see more people logging in. I cannot do new questions today. My apologies. I may not be able to do any discussion on posted questions either. There's just too many of them, okay? Next question, Bablu 12. Bablu has a student visa situation. So he's got 2 years left on his H1. Green card is also going, well, it's not been sponsored yet, I see. You can join MBA, then you got 2 years left, as long as your perm is filed before your 6th year of H1 begins, counting also the recapture time. You will have no interruption in your work. So file perm after you come out of MBA, file perm before the 6th year begins. That's what you're looking for. Okay. Prasad says my priority date is July 14th, 2011. Will there be any forward movement in coming months? Nobody can predict that. I'll have to see the trend for the next 3 or 4 months before we can get a better handle on what USCIS is thinking. Wife is on H1B. Even if you file her 485, she can continue on H1B. And she can keep her priority date too. And she can, when her priority date becomes current, she can file her own 485 as well. And that way, whoever comes first gets it. But that's certainly something I've talked about earlier in this conference. You can have multiple 485s. How soon can I travel to India? If you have an H1, H4, L1, L2 visa already stamped, you can travel once you file your case. USCIS tries to adjudicate advanced parole EAD applications within 90 days. Once you get advanced parole, you can travel then. Okay. The law is if you travel on H1 visa, you should come back and join the same employer, working with the same employer on whose H1 you had left. That's what the Cronin memorandum suggests. Okay. Shankar wants to know, my friend was working with company A in India. They filed his H1B. He came to USA without work, knowing that he didn't have work. That can be problematic because if you enter USA, even though your H1 was approved, guys, I will definitely not have any time for discussions. So I just hate to keep you holding. Feel free to hang up. There's a whole bunch of people here. I may not be able to do, I will not be able to do any new questions or discussions. We still have some questions left on the original file. Okay. So he should not have come in. If he comes in knowing that there is no job just because his H1 has been stamped, he can't come in. And he cannot work anywhere except for the company that sponsored the H1. If I were him, I would go back to India, get my H1B sponsored through another company, come back in again, probably after getting a new visa stamp. Okay, that's the way I would do it. Shruti wants to know, employer is filing for H1B renewal next month. I'm working in employer-client model. Employer is open systems. Working at the end client, there's no middle vendor, I guess. So there are two locations, both within a few miles of each other, same metro area, New Jersey and New York City. Should we be filing two LCAs? Look, I like to do, if possible, two LCAs just to avoid any controversy. That's the way I would do it, but it doesn't look like it should be necessary. It's the same end client. same job. So even if you did not, if you just did one LCA for the beginning job, I think you are protected without an amendment. Okay, but ideally you should do two, just because that way you've covered all the bases. And if the fraud detection directorate or whatever they call it these days comes, they know where to find you. Shobit says my wife's passport has expired. If she applies for H4, will it be rejected? I had this issue come up yesterday. I said, look, don't debate, just file for her renewal, her extension, okay? And wait as long as you can, and then file for H4, okay? Um, you have a marriage certificate issued in USA. Would that be enough? And the answer is, well, that depends. Did you get married in USA again? If not, if it is like a certificate from the Indian consulate, you probably should get a couple of affidavits from people who attended the marriage. If you were married under Hindu Marriage Act in India, you will not have any particular certification. Affidavit should be enough. If, on the other hand, you went for a court marriage in India, you should have a court certificate. Okay. If you want to change from financial analyst to software developer, you'll file an H1B amendment. When you do transfer, you'll also do it. Well, basically, you just give the new job description. Don't have to do anything more than that. If I join a job with 1 year experience and bachelor's job description, but I have master's, can I file EB2? No. Only if the employer is willing to give you a job in the future that requires a master's degree plus, you can file EB2. Otherwise, you are joining an EB3 level job. Okay. Prachu says, working on L1A visa with company A, they'll file for my green card, but now they are not ready to file. Currently, I'm in the 7th year. Can I apply H1B? Well, H1B is not available if 7 years of your H1 are gone. So you have to go outside USA for 1 year. Okay. If you leave USA by June 2016, by June 2017, your time will be over. Best of my knowledge, you cannot apply in April of 2017. You'll apply in April of 2018. Because as far as I remember, USCIS has said that your 1 year outside must be complete before you can apply. That's from what I remember. Okay. So next question is S. Kanda. Employer is deliberately delaying 485. I would be very hesitant in filing 485 based upon a letter given for I-140. I think that's inviting trouble, inviting allegations of fraud. I would stay away from that. Really, there is no solution to the problem where an employer will not cooperate in filing the 485. Okay. Unfortunately, employees don't have any good options. Aap Desai says, for 485, will they accept dual language birth and marriage certificates like English and Marathi? And the answer is yes. I planned India visit 6 weeks from November 15th. Both of us have valid H1B stamped. Can we travel? Look, one thing is quite clear. The primary 485 applicant can travel when they have an H1B visa and 485 is pending. They can travel using the H1B visa as long as they are coming back to work for the same employer. It's also clear H4 spouse can do the same thing. But can the spouse who has an H1 do the same thing? I do not know. You can check with USCIS. Your case is clear. If your spouse were on H4 visa, her case would be clear. But if she's on H1, it is not a clear case. If her date becomes current, again, we are talking about multiple I-485 filing. And I've said this before that that's okay. Prasad 121, priority date is July 14th. Will there be any forward movement or will it go back again? We don't know the answer to that question. We'll see over the next few months. And I've already answered this. If wife is on H1 and you apply for her 485, she can still continue on her H1. Okay. Next question. I have a question, Ray. Secondary beneficiary of a family-based green card. My aunt is a beneficiary of a family-based green card that was filed on her husband's behalf. So if she applies for a visitor visa, does she need to mention anything about this petition? I think she should. Because the question is usually wide enough. It says something like, have you applied for a green card or has anybody ever applied for a green card for you on your behalf? And I think she should say yes. That would be my guess. Okay, so this is the last question and pretty much 5 minutes only remaining of the 1 hour that I had budgeted. I am pressed for time, as I said earlier, so we'll not do any new questions or any discussions. I think I have answered everybody's question, at least to the extent that I could guide them. Next time, we'll make sure that we only have 20 questions, no more. Any more, we don't have enough time for it. Bhatti says, I'm on the 8th year of H1B, I-140 is approved. Priority date is August 2010. I'm planning to apply for I-485 EAD AP. I got an RFE on my H1B visa extension. See, H1 visa and 485s are usually not mutually connected, but they can be if there's an issue of non-payment of salary, fraud, a pattern that shows problems with the H1, or you're working in a place where you're not supposed to be working. So other than that, filing 485 and H1 are not connected. I think you should talk with your lawyers exactly what documents you need to submit. Birth certificates, get affidavits, get certificate of non-availability from the municipal corporation. If you cannot, at least file with 2 affidavits. In the meantime, procure. I think if you procure a certificate of non-availability by the time an RFE comes, you should be okay. That's my guess. Can I apply for 485 myself? As long as you have a letter from the employer, sponsoring employer. And you were the one who was asking the question, where do I find the job description, same or similar? And that would be in your PERM application. If you want to do AC21, look at your PERM application. Folks, my apologies. This will have to be the end of the call today. I'm pretty sure I've answered all the questions. If somehow I misunderstood somebody's question, there's not much I can do at this point of time. We will congregate again in 2 weeks. I'll talk to you then, and I'll make sure that our team cuts off the questions at 20 or 21 so that we can devote more time for everybody. Thank you for being here. Always a pleasure talking with you.
Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.